in lunch hour, but also to attend to my matters I did in the morning in the regional court. Due to technical problems, I still have to deal with those matters on the system.
As the court pleases, may I proceed?
You can proceed.
Mr. Inambao, let me remind you, this matter I'm dealing with is not a small issue. It's not only an issue relating to lawfulness, but it's also a sensitive matter. I just want to let you know. Now, do you agree with me that taking someone's password to a phone to have access, uncontrolled and unrestricted access, is actually taking a key to a strong room where there may be sensitive documents, lawyers' documents, doctors' documents, anything, email correspondences and so forth, and trade secrets?
Your Worship, once a piece of evidence is seized, chain of custody must be maintained and kept in a safe and secure place where there is controlled access only until it is examined. Sometimes during the investigations, we do request for access so that when we forensically subject the devices to the forensic, we don't have to use brute force if the phone is unlocked.
No, look, you don't get it. You don't get it. The question is, when you take someone's password, you have unrestricted access to the content and data on the phone.
Yes.
Because there is no court order guiding you what you should not search for and what you should search for. Do you agree with me? If you take somebody's password to get access, there is nothing controlling you as to what you should have access to.
Your Worship, as I indicated, when we search phones, we don't manually search phones like you go on the device and search. You use a forensic toolkit to examine, to acquire the data upon which you will search for specific pieces of evidence in which you can actually even use, dates. For example, if you are looking for a specific date, you will go for that date. You go for the messages. You go for calls. You filter what you.
Yes, it doesn't matter. My client's instructions are that, and that is Lydia Erindi. On that phone, there are communications with her doctors, medical data on that phone.
It's possible.
There are communications of legal matter with attorney-client privilege information.
It's possible.
There are communications of very, very sensitive nature with her husband.
It's possible, Your Worship.
Sir, have you read the judgment of Namcor versus the magistrate of Enana? I'm only asking if you have not read
No,
it.
I haven't.
Have you read the judgment of George Simata versus the director of Anti-Corruption Commission on warrant of search?
I remember reading it, but it's been a time, some times ago.
Do you know that even when you have a warrant of search, it is only the officer specified in the warrant who can search, not every officer?
That's correct.
Now, the password that was given to Inspector Anna, there is no court order, there is no guideline as to who will have access to the phone. Do you agree with me?
Your Worship, the phone was not given to Inspector Anna.
Okay. It was given to who?
One of our officers who was present.
Who is that?
Your Worship, I don't need to divulge the name.
Why?
Because when we go out, for example, to a place, you have the person that is watching the person that is arrested. And then you had to make sure they don't cause harm to themselves or cause harm to the other officers.
No. But the public prosecutor did not put contrary instructions to my client when she was cross-examined to say, no, it is not Inspector Anna.
The prosecutor was not present at the house of the Malakia and his wife when we arrested.
Mr. Namanje, just before
I think, in fact, Mr. Lindy has
before
been
you
granted
proceed, I just want to say, Mrs. Lindy is not an applicant for now in this proceeding.
Yes?
Yes. In the bail proceedings,
But-
where does that take the case for your other applicants in this
At
proceeding?
the beginning, Your Worship, we are entitled to do that. When you look at the case of S versus Likanye in the Supreme Court, Your Worship, the high treason conviction that was set aside, the state functionaries, in particular police officers, they are not permitted to unlawfully abuse powers they have, so that this court were in consideration of bail. If the court were to find that there was
Mr. Namanje, I understand, but in your line of questioning now, Ms. Ilindi is not here. She's not an applicant in this matter. I'm just asking, where does that line of questioning go
it's coming
in these proceedings?
Okay, is that what you are?
Yes.
It is still relevant. It is still relevant because it's one and the same operations, and I'm going further to demonstrate that this is a pattern in this matter, abuse of power. It's the same thing, Your Worship. May I proceed to the next one?
I don't hear you. Yes, I'm not hearing.
It's a pattern, Your Worship, police officer. It doesn't matter, Ms. Erindi has since been granted bail. If in the same operation, the officers were using the power they have for legitimate purposes to abuse those power, you are entitled to look at that in exercise of your discretion.
In a bail application, I'm saying.
Yes, in a bail application you can.
For now, because she is not here. Yes, so where does that line of questioning
Your
take-
Lordship, remember,
assist the court?
Malima.
Can we have one speaker?
Yes.
Where does that line of questioning take the court in deciding the issue before it? That is my question.
Just the same way, we have had evidence about Austin Elindi, whose bail application is before another magistrate, Malima, who is, I do not know where he is. We have had evidence about corporate entities that are not part of this bail application. It's one and the same. We had a lot about many parties. In fact, and many other parties. It is relevant,
I hear we have a lot of other parties, but I'm just saying in a bail application now, does that assist the court to decide the
it does.
issue of bail?
I will refer the court to case law that even when it is bail application, the fundamental rights to a fair trial includes a bail application. And the officers of law enforcement, they are not entitled to abuse those powers.
I understand that aspect.
Yes.
I'm just trying to say, in the answering the question,
Yes.
whether to grant or refuse bail, that line of questioning.
Because
Yes.
if they were using power for an ulterior purposes, your Lordship, it also ties it with necessity of arrest and so forth. Your discretion, because your Lordship, the principle is that you cannot assist state agents if they abuse power. The judgment of Mushimba and so forth tells you, your Worship, that state officials can never use the power they have for good reason to break the law, even if it is in investigation of crime. They cannot.
Yes, it appears you are not getting to my question. We can move on.
Oh, ask the court, please.
Yes.
The court said I must move on.
Your Worship, but I think contextually also, this court will appreciate that when the day comes when this matter comes to trial, the state would be entitled to produce the bail record, certified by the clerk as an exhibit in those proceedings. Your Worship. Now, if something is said about someone, whether he or she is no longer a participant in those proceedings, but who was a participant at the relevant time, Your Worship, and those issues are not placed in dispute, there is evidence that can be held against that person, Your Worship. So there is also the broader context that this honorable court should appreciate.
I know from the onset we had reached a point where the court even said, considering that bail proceedings, the record forms part of the entire proceeding.
Exactly.
So that is what.
I am indebted to court. The court said I must proceed.
You can proceed.
Now, look, I asked you about I even lost where I was. Just the last question.
Yes, you referred him to the issue of whether he knew or he read the case of Mr. George Smart,
Yes.
and he indicated some time ago.
Yes,
that was the last.
Yes. Remember, in that matter, for your information, the High Court of Namibia decided that your officers, only those who are specified in a warrant of search, could conduct a search. If a warrant officer does not specify an officer, then that warrant will be unlawful. Do you agree with me?
And I know that.
Okay. Now, why did your team went for a password, assuming you are correct, you can take the phone, instead of applying for a warrant of search after the fact, after you have taken the phone?
Yeah.
Why did you commit two wrongs at the same time? One is taking the phone without a warrant. The second one is to proceed again and ask for the password and the PIN. Why?
In the course of investigations, in fact, if the court allows me just to step back a little bit earlier, as the court and Mr. Namanje were busy discussing, fresh memories are coming back. I remember in my examination in chief, I testified that we were looking for Mr. Malakia Elindi and his wife at a residence in Pioneers Park, if I'm not mistaken. So there was no way we would have gotten a search warrant for that house where we found them, because we were not aware of that house. And there was no way for us to have obtained a search warrant in that regard. And I just want to refer you even to, I think, one of the person that you were asking. We didn't have a known address. We had to get people from here and there. So we seized the phones. But as I was explaining earlier, that when we seize a phone, there are two options. You can seize a phone where a person, upon asking if they want to give the password, if they are willing to give, they will give you. If the person is unwilling, they won't.
So you are not answering the question. The point is, first of all, Mr. Malakia doesn't have residence in Pioneers Park.
I'm speaking under correction, but as
Why
far
are you
as
speaking under correction?
no, it's because I didn't go to that residence. In terms of the records that we had, it was a residence not in Glenvenduk. So when our officers went there, they went and found out that it's his property that he's renting. So, but by then we already had some intelligence that there's another house this side.
But you don't need an address to get a warrant of search.
No.
In relation to, can you just listen? In relation to a cell phone. A cell phone, you can get a search warrant to seize anything that you find anywhere, including on the person of a suspect.
We always try to put an address as part of the standing procedures.
Okay.
Put an address. In fact, even the magistrates, before they sign, in order to protect ourselves, if we want to go and search, we need to make sure that we put a physical address.
So in other words, you wanted to apply for a warrant, but the problem was that you didn't have an address.
No,
Is that what you are saying?
No, I'm saying from all the other activities that we had, there was no way we would have applied for a warrant when we found Miss Malakia on the other side.
But all I'm saying, but you are saying it as if it was the reason not for obtaining a warrant. You
No.
are contradicting yourself.
I'm
You
not co-
appear to suggest why you did not get it is because there was no address.
No, I'm saying despite there not being a warrant,
Yes.
there is no way we would have obtained the correct warrant because even the address that we had, it's not the address where we found her.
Okay, this illegality is continuing. Up to today, you are in possession of my client phone with access to that phone. This illegality is continuing at the time of this bail application.
Your Worship, at the time, investigations is still ongoing. We know that some of the suspects have even, run from one place to another. And, given what we had to work with on that day, we needed to make sure that we try to contain that.
Okay.
So it's not that maybe we are keeping and we are busy accessing your client's phone. The phone carries activity logs. Part of the requirements is that once you seize a phone, you isolate it from the network so that it doesn't anymore receive, messages or calls, because it would be tampering with evidence if we allow, if one of the investigators start fiddling with this phone, 2 days later after it was seized, it means we have tampered with that evidence.
Okay, but the point remains that phone is open. There's no restriction. Even if there are no calls coming in, the content and the data is open as this room.
It's only when it would be examined, forensically examined, and it's not going to be the phone that will be examined on itself. The data of the phone would be forensically examined through an examining machine.
Okay, when Mr. Mulunga was arrested, it's common cause, it's a notorious event. He was photographed when being picked up. Do you know about that?
I know about that.
How did it happen?
I believe if Mr. Mulunga was very honest, he would tell you how it happened. And I'm saying so because I was personally at that residence. When I came at Mr. Mulunga's residence, there was a vehicle of the media standing in front of his house. I requested for those people to move away from there. In fact, they refused. I had to tell them that, look, you are obstructing the course of justice. Mr. Mulunga all the time was watching from his CCTV footage. I'm sure I can confirm that. So I requested them to go away. Your Worship, we were so kind that I even asked the team to reverse the car in the garage or towards the garage of Mr. Mulunga.
Mr. Inambao, let me but did you tell the public prosecutors all this before Mr. Mulunga was cross-examined so that they pass that information to him to comment on?
No, they didn't. I'm not sure whether we spoke about it, but what happened is Mr. Mulunga is there. I was standing in his garage. I told the team, even one of the colleagues that was the driver of the van, I told him reverse.
Okay.
And I wish, at this point in time, I wish we had packed the van outside so they could have taken a proper photograph of it.
Just remain. This is.
Sir, can you just answer the question so that we can...
No, but Your Worship, we cannot allow that. We have previously
The court is already questioning him that just answer the questions. Yes,
No, but it's
without...
not just about the questioning of answering the questions, Your Worship. It's the conduct, it's the demeanor that this court should admonish them when it's conviction. That's the issue.
Yeah, exactly.
That's what the court said. Just answer the questions and then we move on.
Thank you, Your Worship.
Yes.
This is a serious matter. Look, you knew that at the beginning of this bail application, state was given notice that one of our ground is that there was abuse of power and leakage of information to the media as part of the process of arrest and investigating. Does it mean that you did not advise the public prosecutors of what happened in relation to that leakage?
Your Worship,
What you are saying now, what happened?
if the prosecutors had asked me, I would have informed them.
Okay.
I would have informed them. In fact, as we were speaking with Mr. Mulunga, he did tell me that the media by then had already called him. So as to how they called him, I have no idea.
Let me just ask you, but do you agree with me that when you make allegations of what happened there, but they are not canvassed with Mr. Murunga when he was in the witness dock, that is unfair? Because he has testified already.
This was not part of the evidence that we had collected. And I did not know that I would be asked questions as to whether we had leaked the media. I mean, Your Worship, I've said part of the reasons why we had seized the cell phones, it was to limit the knowledge that we have started arresting these people. We wanted to make sure that we have arrested people first, even before the media knows, because the moment we do that, suspects will start running away.
I want to put it to you. It is very clear. Did you dish out information that you are going to Mr. Murunga's house? Did you tell all and sundry that you are going to that house as officers?
No.
I want to put it to you, sir. You invited the media. There is no way, if you did not dish out that information, the media would have been there. You are just hiding it.
Your Worship, I don't know whether I must answer this question.
You
Do you
must.
have any comment? Yes, you can comment.
No comment, Your Worship.
Yes.
No comment, because there has been no evidence that has been presented that ACC or ourselves as the investigating team has leaked this. And this would be unprofessional for an investigator to do that when you are still looking for. I mean, Mr. Mulunga was the second or the third person we arrested. I mean, we were still looking for more people.
Look, let me make it easy to you. But the courts in this country has already found against you in respect to Mr. Hairuru. It's something you do. It's a pattern of combat. I will, in my submission, show a judgment where Mr. Hairuru was arrested in front of media cameras. So it's something you officers do.
Worship, I have to object to that line of questioning. I think the witness has answered that he did not invite the media there. So how is it relevant if the witness has already said we did not invite, in fact we found them there? And even if that question was not put, it was irrelevant to us to put that to Mr. Mulunga. It was none of our concerns to ask how he was arrested.
But I'm asking a different question, or what I want to...
Yes, the question has already been put and he has answered.
Yeah, exactly.
We can move on. Yes.
Why you do that is to do it so that the matter is massively published in the newspapers. You start working on your case to strengthen it before accused person appear in court, because you want a public narrative. That is your inappropriate, unlawful modus operandi.
That is a lie, Your Worship. Okay. Even if there was, at any point in time from the officers that we worked with, there was no point we wanted to discreetly do this so that we can arrest everybody that was involved and have them in the custody. Your Worship, we were looking for more than 10 people, and now we start to compromise the information with the second person. How would that assist us?
Another issue.
Your Worship.
Is Mr. Elindi facing charges in the amount of 480 million?
Your Worship, I have testified in this court. I have given the figures that are involved. If we add up those figures, they go to a little over 400,000. So I'm not sure where Mr. Namanje is getting 480 from.
Listen to the question. Is you caused my client to be arrested including Mr. Peter Elindi. Is that correct?
That's correct.
Is there any charge in which an amount of 480 million is involved?
I've just answered the question.
Which is? The answer is?
I've just answered the question a minute
I didn't
ago.
get it. Just repeat, sir.
I said, during the testimony that I've provided
Yes.
before the court,
Yes.
I've given the different amounts. I've given 35 million 747,615. I've given 73 million. I've given 238 million. So if you add those ones up, it will round up to about a little over 400
400 what?
million.
Okay,
So
no, I will not leave you. But remember, I'm not talking about everybody. I'm asking Peter Elindi.
Mr. Namanje,
Yes.
you were here since I started testifying.
Yes.
Did you hear me testifying that Mr. Elindi is facing a charge of 400,000?
You see what is happening, Your Worship, now.
So just answer, if you did not testify about 400, just say, I did not testify about 400.
I did not testify about the 400 million.
Exactly. But do you know,
480 million, I mean.
do you know that on the date of appearance, it was stated by the public prosecutor that all accused persons are facing charges of 480 million. That includes the Elindis.
Your Worship, I was not in the court when the accused persons made the first appearance.
Was it you? I just want to know, because this is inappropriate and it's a wrong process in our court and it's manipulation. I want to ask you, what does it mean that it was not you who passed that information to the public prosecutor who placed it on record?
Your Worship, we provided evidence to the court or to the prosecutors, following which the annexures were drafted and the accused persons appeared before the court.
Okay. Do you support such allegations against my two clients that they are facing charges of 480 million?
I've testified before this court and I've provided the values of what your clients are facing.
No, I know. But those values are not 480 million.
Yes, that's been ascertained.
I want to then put the following. It is in favor of my client that they cooperated at the time of the arrest. Both of them, they cooperated. They cooperated when you went to them. Nobody wanted to run away, Mr. Marakia. Peter brought himself to ACC office. They cooperated.
It's not like they had a choice.
That's not what I'm asking. They cooperated. I put it to you.
Yes, they were arrested.
That's not the question. They cooperated, sir.
Mr. Namanje, when a person visits my house with a warrant of arrest, I mean, they just have to execute the warrants of arrest whether I like it or not.
Yes, but did they cooperate or resist arrest?
They did not resist arrest.
Okay. They did not attempt to run away.
Yes.
It counts in their favor that they are Namibians.
They are Namibians.
It counts in their favor that they have substantial assets. Remember, in judgment, it says assets, it's a relevant consideration to bail. It counts in their favor that they have assets all over.
That's what you are telling me.
Yes. And you are not disputing.
I hear you.
Yes. It counts in their favor that they each one employ about 26 people.
I hear you.
It counts in their favor that, in fact, they were trying to conclude a mining deal that may result in employment to Namibians.
I hear you.
It counts in their favor that they did not interfere with investigation.
Investigations is still ongoing.
That's not what I'm asking.
Yes. Investigations is still ongoing.
That's not what I'm asking. I said it count in their favor that they did not in the past. I'm talking about.
In the past.
Yes.
You are telling me so and I'm hearing you.
Yes. Now, do you know about the law, the principle that even if a court has some fear, it must still consider whether appropriate condition could be attached so that a person gets bail? Do you know about that principle?
That's correct.
Okay. It's not my client who will decide whether they will get bail. It's not your decision. It's not the decision of the prosecutor. It's a decision of the court.
Of course.
Do you know that the investigating officer's position is also, it is good for him to be heard, assuming there are conditions, the investigating officer, because you have no choice if the court grants bail.
Of course.
Now, assuming the court grants bail, do you rather let my clients be reporting each week or not report at all? Which one is better for you?
Your Worship,
Which one is better? No. The court is writing down. Which one is better?
I have no comment on that one.
Oh, okay. If my clients are granted bail, would they better pay 10,000 or 50,000? Which one is better?
That is to be determined by the prosecution. I mean, I'm saying that is to be determined by the prosecution.
Oh, okay, that's fine.
I mean, yesterday you were telling me I'm the investigator, it's the state, so.
Okay, no. All I'm saying to say, you cannot choose whatever is
Yes,
best. Okay.
I'm
It's up to
I'm
them.
not in control of that. In fact, it's up to the court.
Up to the court. Look, I will ask because given the poor and weak nature of the state case, in fact, I will ask that the accused person be released on warning. Any comment you have?
I will totally disagree with you. I've stood here 2 days almost testifying, demonstrating how much evidence we have gathered,
Yes.
and how advanced is the investigations. So I will totally disagree with you that how poor this case is.
Okay,
We have done quite significant work in this case.
Okay, fine. I will demonstrate in when I argue. But if they are reporting, do you prefer them reporting to Windhoek Police Station or ACC office, assuming they get bail?
ACC,
To whom should they report?
I think the investigating officer. Then we will, of course, put some administrative measures in the office.
And they said they would also hand over their passport. Do you prefer that they remain with the public prosecutor or yourself? I see you are looking at my colleague. He will not assist you.
Well, I'm not sure
We don't keep passports. So
yes,
Can we maintain the decorum? The court is in session.
yes, I'm not sure the prosecution keeps
Okay.
exhibits.
Okay, fine.
So-
So it's you, then the investigating officer.
Definitely.
Okay. Sometimes in some cases, accused person get bail, but in addition, the court attach another condition that they must not apply for traveling documents. Do you have a problem with such a condition?
No.
Obviously,
Just a minute. Yes, it's opportune time for the court to adjourn.
I only have 2 questions, Your Worship. I'm done.
Yes, we have been here since morning. It's fine, you can have your time. We just roll the matter to tomorrow,
Tomorrow.
if you are available.
I wanted to. Okay then. As the court pleases. To tomorrow then.
I'm available tomorrow.
Yeah, we roll the matter to tomorrow. Yes, that's it. You are still in the hall.
Thank you, Your Worship.
Yes, the court adjourned.
Authorize.